Hey, hello, hello, hello. Hey, we have a sign up sheet if you're interested in making a 15-second comment.
Yes, sir.
How's your baby? My baby is got the flu. They almost got. They've been trying to get blood out of him all day. They can't get blood out of the guy. They're wearing him out trying to get blood.
Okay, it's 3:30, so we can start. And I'm going to ask Representative McLean to open us in prayer.
Thank you, Mr. Chairman and members of the committee. Let's bow our heads. Dear Father, bless us today to make sure that whatever decisions we make in your name. Father, you know, today is one of those days that when the sun came up, we all got up and we all wanted to make sure that we could do those, whatever we did it in your name. And Father, make sure that we realize that we vote from compassion, that we realize that what we've got to do is make sure that workers in Georgia are treated fairly. And also employers, Father, just don't think that one is without the other, but we got to have them both. And I just know this committee, that we have a chairman that will make sure that we all realize that we all in this together. And I will always ask this in the name of the Lord. In Jesus' name, we pray. Amen.
Thanks, sir. Okay, we've got one bill before us, and just going to give a little bit of historical perspective. So, because this bill involves workers' comp, for those that don't know, we have an advisory council that is made up of 110 members appointed by the chair of the State Workers' Comp Board, and he's here somewhere. I saw him right there, dead center, Chairman Vinson. And so last year when we heard the bill, we heard probably an hour and a half worth of testimony. Do with all workers' comp bills. They presented us with a 2-page white paper that was not only neutral in explaining the effects of the bill, but their position was neutral, which a little unusual, wouldn't you say? So, because usually they come out with a support or non-support, but they were neutral. But I did go through the process, and so we're at it now. So having had, close to 2 hours testimony, going through the AC, it could be within my right to call for a vote now, but we're not going to do that. I know some of you have traveled a long way to this bill, but we're not going to be here for an hour and a half. So I want to make your comments as quick as possible. I don't know that anybody's mind is going to get changed. I don't think any member of this committee has not been addressed by both sides, so they've got the facts. And so we're gonna move through that. We're gonna let you speak, but a couple of ground rules. I do want your comments to be made quick, and if committee members, I want you to jump to the end to your question instead of, what you feel about the bill or whatever. If you've got a question, let's ask it and move on. So just to give an overview of the bill, this has to do with longshoremen and it is a little unusual because they participate, the employers, in a normal situation, employer, like most of us have state workers comp that we pay a fee to an insurance agent, we're covered. What makes this different is that it's a concurrent programming means there's two things going on at the same time. These are employers are paying for a federal program and for a state program. And so it is an extra burden on the employers. The benefit to an employee is the federal program pays better, but it takes longer to get it. So what is currently happening, because I don't want to hear the word double dipping or people getting paid twice, because that's not happening. What is happening is somebody gets hurt and they file for state unemployment benefits and they start getting paid pretty quickly, but they also file for federal benefits. And when the federal benefits, which is always later in time, kicks in, not the employer, but the benefits are reimbursed to the state, so that there is no double paying. They're compensated for that, but the fees to the insurance agent aren't. And so this bill seeks to get the longshoremen's union or those employees, and we'll have some definition of who all that includes. This is to move them from a non-concurrent, which means they will be like most businesses. They'll just participate in one of them. So, did I explain that correctly? A few head nods. So with that, the sign-up sheet. Okay, Paul Mosley. Come up, tell us who you are, who you represent. Yeah, you can do either one, table or the podium. Okay, I got you on.
Good afternoon, everybody. My name is Paul W. Moses Sr. I'm the president of the International Longshoremen Association, Local 1414 in Savannah. We are the largest labor union in the Port of Savannah. What I want to discuss is, and Mr. Chairman, you summed it up pretty good, but there is a few things that's left out. It takes a total of 16 weeks for an individual to get even an increment of an answer from the federal government. So that's 16 weeks where you're talking about individuals that's not working for 16 weeks. Therefore, you're forcing individuals into bankruptcy and everything else. Now, to me, that's not the way you treat the hardworking citizens of the state of Georgia. These are the people that's paying the high taxes to the state of Georgia. It makes no sense. 16 weeks, let me correct myself, 16 months, 69.5 weeks in order to get on the docket. That's my correction on that. 16 months, 69.5 weeks before an individual are allowed to talk to the federal government to even see whether compensations will kick in. On top of that, to the staff, these are the same women and men and women, because you said longshoremen, so let me be correct. We have women out there working too, single parent women who are taking care of their family. You have single parent men that's out there taking care of their family. And just put yourself in that situation. If you wasn't drawing a paycheck for 16 months, where will you be? It's a lot of people that make good investments with their money, but it still will put a financial strain on anybody when you're talking about something like that. And again, I have to always drive the point home. These are the people who are paying the highest percentages on taxes in the state. When management come in, Gateway Terminals and all these other terminals, they came into business, they knew what they were coming in business for. They knew what they came in business to do. But during the time of these individuals, if you pass this bill, you're forcing individuals into who are hurt. You're forcing them back premature when they're not fully healed to sustain another injury. I have a young man here, statement from a young man by the name of Samuel Green. Young man, well, I say young man, but he's in his 60s, full of life. Loved to skate, loved to dance. That was robbed from him in July of 23 because a container, something that he wasn't looking for. He's sitting in the lead picking up a box, supposed to be picking up a box. A container cut loose from a machine, drops on his back. You know what happens to him? Management, he turned around. After this happened, he's on his way to a doctor's appointment, and then all of a sudden a car ran into the back of his car. Because management insurance company, and I'm not going to blame them, but the insurance company found out about this, they decided that they didn't want to pay this young man for workers' comp anymore, and he needed the surgery. But the good state of Georgia kicked in, and this young man was able to have his insurance. We're not asking, just like you said, it is not no co-mingling or anything. We're just looking for you members to represent the members that you look up to And when you ask those people for their vote, we're not looking for nothing extra. During the time of the pandemic, and I'm going to sum this up, during the time of the pandemic, my men and women didn't take not one day off. While individuals for the house was on breaks, you had management working from home. My men and women showed up every day, and we wasn't even considered to be essential workers. Why is that? You couldn't get the medical supplies to the hospital if we didn't get it off the ship. You couldn't get it in the grocery store if we didn't get it off the ship. We were stuck with dealing with individuals from foreign countries who we didn't know, who we had to talk in these people's face. We didn't know what their vaccination or none of this stuff was. But now we're going to come up with a bill to hurt these individuals. Only thing I'm saying, before you cast your vote, I want you to think about some of the things that the governor thinks. I want you to think about what this young gentleman right here just prayed about. Let's think about the individuals, the hardworking individuals that represent the state of Georgia. Please vote no on this bill. Thank you.
Don't go anywhere. 23, is that Chairman Petrie?
Yes, thank you, Chairman. So, sir, thank you for giving us this information. It's the first time we've heard about 16 months. So, and to be clear, no one here in this body is trying to hurt workers. That's for sure. They have differences of opinions, but that is not the case. So, help me to understand this. So nationally, is this the case? 16 months for anyone in your profession all across the country. Why are you paying union dues for this coverage?
We're not,
seriously, I mean,
we're not paying union dues for this.
You're
coverage.
not. Okay,
No.
you're not.
No, we're not, sir.
You're not paying somehow for that coverage.
No, sir.
Okay.
No, sir.
It's just available to
It's
you.
available to us.
Well, somebody's paying.
But the company is paying
Yeah.
it. But now,
Okay.
let me be clear about this.
So the company is paying for that
Right.
and for you to have coverage through the
Right.
state. Correct?
So now let me give you this bit of tea, because a lot of people don't understand this. If there's not a ship on that dock, we don't make any money. We don't have a guaranteed 40-hour week job. We only work as needed. So if you have an individual that get hurt, they're in the pickle. These individuals, they're stuck. We only work as needed. If we have fog, we have snow, which the good state of Georgia, we had snow the other day, and we weren't able to go right to work immediately. So we have all of these challenges when we get up in the morning to come to work. And I say we, I'm talking about my members. And let me be clear, I'm only talking about Local 1414. You have Local 1414, you have Local 1475, you have Local 2046. But in my union hall alone, sir, we have 3,000 people working in and out of that building. 3,000.
All right, let's keep going. Who's 27? Chairman Carpenter.
Yes, sir.
Thanks for being here. I'm still flashing. Then we're live. Thanks for being here. I just heard you say you have about 3,000 members. Do you have any sort of, is there an internal benevolence fund that you guys set up for workers? So if they run into this delay as they're waiting on, the union itself doesn't have any kind of benevolent fund that everybody chips into to kind of help folks, or?
Well, what we have, sir, we don't have a benevolent fund for the union because, again, we're federal mandated. DOL watches everything we do. We can't just take union funds and just say, okay, we got a member that's out, we can give them the money. It doesn't work like that. We fall under strict federal guidelines.
Okay. Yeah, I mean, I don't know the layout. So I didn't know if you guys did anything, because like if something happens in our community.
You know what we do, sir? I'm gonna answer your question. You know what we do? The men and women, when we have an individual who gets hurt that the company don't want to pay for, it's good you asked me that question. We go in our own pockets and give it to the member just to help them pay bills.
Yeah, I assume that's what we do at home when police officers or firefighters have issues. Everybody just kind of
we just chip in. So it's like excuse my French, it's like a pass the hat deal.
Yeah.
Which shouldn't be the burdens of everybody in the building.
Sure. I just didn't know with a union organization if there was a leg of that organization. Thank you.
Okay. Representative McLean.
Thank you, Mr. Chairman. And thank you, Mr. President, for being here, too, and explaining it, too. But I noticed you only spoke of the longshoremen, them. Is there any other employees that work, that this is going to affect at all?
Yes, sir. It'll affect those individuals who are in the area of the Tybee Island Thunderbolt who are working on ship repairs. This thing goes wide. You're talking about an estimate from research, about 66,000 people will be affected by this bill. Because you have people that's working in the shipyards that will be affected. Anybody who's directly attached to that beautiful river, that beautiful port we got in Savannah, could be meaningfully affected by this bill being passed, sir. Yes, sir.
Okay.
Thank you.
Let's, okay, Bruce, that's all the questions. Thanks, sir, for
Thank you.
coming here. Bruce Caraway.
Good afternoon. My name is Bruce Caraway. It's an honor to appear before you again. I have been doing workers' comp law this is my 40th year. I do practice Longshore and Defense Base Act. It's under the Longshore Act, and I've been doing that probably for the past 25 years. I do more of a national practice. I do have a perspective as to how these cases are handled in Florida, where you don't have concurrent jurisdiction. Mississippi doesn't have concurrent jurisdiction. I will say that I think the port in Savannah is much better than those ports. I think it has the infrastructure. I think it has the workers. Where whether or not you pass this bill, it's not really going to make any difference in the cost of freight. At the outset, I'll say that if you pass this bill, it's going to be a tragedy. It will be a tragedy if you pass this bill, especially without further study. As far as I know, this bill popped up last year, didn't go through the chairman's committee. Bobby Potter's committee, Bobby's here, he does the legislative committee through the State Board of Workers' Comp.
He did.
His committee hasn't studied this issue. We did have a licensure committee that I was on, and Brian McElreath was on that also. We had one meeting. We met in Jekyll, and we talked about the issues. That's where the white paper came from. But it wasn't real study. We don't know, what would insurance premiums go up or down if this passes? We don't know. If it changes insurance premiums, how does that change the cost of freight, versus just maybe profit going in somebody's pocket? But what we do know is that it would be a tragedy for the workers as far as what would happen to them if they're thrown into the Department of Labor system. John Grisham wrote a book called Gray Mountain, where he talked about the black lung workers and how basically they're caught up in this same Department of Labor system. And he painted the picture of the company, the coal mining companies, they're holding the cards, and so they know that these black lung workers, it'll take, not 16 months, it'll take 4 or 5 years if that case is controverted until you get a judgment from the administrative law judge. I don't know about you, I can't go 2 months without a paycheck, but to have a worker go 5 years without a paycheck, that's a tragedy. And what that does, it throws the system, throws the workers back onto the state system. And so they're getting, hopefully they're getting Medicaid, maybe Medicare if they qualify for Social Security. They're getting welfare, they're getting rent support. But do we want to pass a bill that increases the role of people on welfare, or would we rather the company that they were working for when they got hurt be responsible for paying for that? I'll just say that overview of the system, the problem with the Department of Labor is that the system, it was bad when John Grisham wrote about it, but it's worse now. Ralph Orberbaum's here. He's going to talk also. He does Defense Base Act. We represent people that are working in war zones. I have a client of mine who's caught up in the Department of Labor system. He's here to testify. But the problem is that the Department of Labor handles not just workers who are working for Georgia companies overseas, it also handles workers who are foreign nationals. So you have somebody who's from Somalia who's working in Iraq and they hurt their back, well, they're entitled to a hearing. And so because of that, the statistics are through the roof. Each judge is handling, 2,000 cases a year. And the awards they write, they're 50-page awards. They're writing like they're on the Supreme Court of the United States. The system is broken. The longshore worker Sam Green that was talked about earlier. That's my client. He got hurt working for Gateway. It was an accepted case. You know, when the container fell and injured his back and neck where he needed neck surgery, you know, he was getting his workers' comp benefits. And then Gateway got hold of a report that said he was in an auto accident. Well, the report was that his car was hit while nobody was in it. So that was the auto accident, was it basically said his car was in an accident. Under Georgia workers' comp, under Chairman Vinson's system, then the company, well, they could file for hearing. They say, hey, we hear he's in an auto accident. You know, we want to go to court and cut off his benefits. And so due process occurs, and if he was in an accident, we go to court and cut off his benefits. In the Longshore system, they cut Mr. Green's benefits off. You know, they didn't, investigate further. They didn't look into it. They just cut off his benefits. He didn't get his neck surgery approved. He went for months and months where he wasn't getting benefits. We filed a claim in the Department of Labor. We're waiting and waiting for them to do something. You know, filed for hearing, waiting the 2 years for the trial to be held. Luckily, in Mr. Green's case, I was able to file for a hearing under the State Board of Workers' Comp. We had a hearing set fairly quickly, within 2 months, and started discovery. Under Longshore, you don't even start discovery for 6 months to a year. So nobody's talking, nobody's exchanging documents, no depositions. Under the state system, discovery starts right away, so you can get to the justice of the situation, so the truth comes out under the state system. So in that case, we filed for hearing, exchanged discovery, and Gateway did the right thing. They started his benefits back. They paid for his surgery. So good for them. I mean, they, when we went through the system, they paid the benefits. But if we didn't have the state of workers' comp, the state board of workers' comp handling the case, he would still be waiting for his surgery. We'd still be waiting for a hearing. And that's a tragedy. I mean, to have someone who, not only gets hurt, can't do things they like to be able to do, but they're not getting their rent paid. They're not not paying for their car. I mean, I have clients that, they lose their house, they live in their car, and then the car gets repossessed. When do they go there?
All right, will you take a couple of questions?
Yeah, and I had one more point to make,
Okay.
if I may. So we can prevent this tragedy, and there's a way to do it, and it's through rational study of the issue, not this hurried meeting out of the blue. We had one meeting last year, but I don't see any economic study of what's going on. I don't see any real back and forth. We've had one meeting trying to negotiate something. We're open for a second meeting. And I'll say that if you look at the statute, OCGA 34.9-243D, it gives the State Board of Workers' Comp the right to write rules as to how an employer can say, we're entitled to reimbursement. So if Gateway says, hey, we already paid this money through Longshore, we want reimbursement, there's already a system in place where they get paid back for the wage loss, they're paid back for the medical treatment. And if there's any tweaks to it, if it's confusing how it's done now, the State Board of Workers' Comp already has the right to write rules as to how it can be accommodated. They can say, here's a piece of paper, fill out the paper, tell us what's been already paid, a little due process, you have 10 days, and then we're going to get a reimbursement for it. So the State Board of Workers' Comp has not fully explored this, and I think there's other avenues where it can be explored without the draconian just stopping the worker having the right to use the Georgia workers' comp system.
Okay. Chairman Carpenter?
Thank you so much. Two quick questions. One, what percentage of cases do you think that are sent to the federal level are considered controversial? There's a disagreement between the worker and the employer. What percentage total of all those cases?
What percentage of cases are before the Department
what
of
percentage
Labor?
ends up going over this 16-month period where you're waiting 4 months before anybody's discovering anything? Are we talking 5% of cases, 2% of cases, 30% of cases? What percentage?
That's a very good question, Representative Carpenter, and it needs study. Let's take a look at it and see how many people this really affects. From my perspective, people call me when there's a problem with the case.
100% of your clients are, 100% of what you're dealing with is. I get that. Yeah. I think that's an important piece to know. And then the other piece is, as far as your firm itself, what are the fees typically that you guys incur out of the settlement dollars that the people get? What's your take on a state issue versus a federal issue? Does that make sense?
I'm
Is
sure
it the
that's
same?
good.
Is it the same take rate? Or?
That's a good question, and I'll answer it this way. In John Grisham's book, he writes about the Department of Labor system, and he makes the point that there aren't many lawyers willing to take those cases because the system takes so long before anybody gets paid. You know, you don't see a billboard on I-95 saying, "Call me with your longshore case."
Sure.
These are hard, and most of the guys that do it are, old like me. You don't have a 30-year-old feeding his family doing longshore workers' comp.
Okay.
So to directly answer your question, in Georgia workers' comp, I'm paid 25% of the settlement.
Okay.
And I've settled a case to the Department of Labor. I mean, this paraplegic. Total value of the settlement was actually $8 million. A lot of that was medical. My fee on that was $60,000.
Right.
If it had been a Georgia workers' comp case, at least on the indemnity part, I would have made $500,000.
Sure.
So personally,
So personally, it works, but your take at the state level is better than the federal level. Is that what you're saying?
yes.
Okay.
Yeah.
Okay.
And the longshore, we charge by the hour. So if it is a case that gets litigated and there's a lot of hours put into it, then I'm getting a good fee on that. But it's still, after 4 years, then I'm going to have to win the case.
Gotcha.
Okay. We got to keep moving. Chairman Bonner.
Thank you for being here. Just my question I've got is, what more is there to know? And from like your perspective, because it sounds like we're at this philosophical difference, right? I don't know how much more study it would require. Even though we're not in session, that doesn't preclude the parties from having these conversations and coming to some sort of consensus, knowing that ultimately, the legislature may be the one that comes to that consensus for you, right? So, I'm just not one to continue to kick the can down the road if it's not productive. So, my question, I guess, is really, what is it going to do for somebody like you to come to consensus on this issue?
Well, for one thing, we can use the current process we have to write a rule that takes care of the problem the employer has. If they're claiming double dipping on some level, I know we're supposed to say that, but I think that was mentioned initially. But if they claim this is costing us 3 times as much as if it was just longshore, I want to see the numbers. I'd like to see Gateway open up your books. What's your total budget for the year? What's the current budget for workers' comp? And if this bill passes, what would your budget be? And if that happens, how would that affect shipping costs? How would that change how many workers you can hire? Is it a difference that makes a difference, or is it just a minuscule amount that helps the bottom line, but it doesn't really help Georgia citizens, doesn't help hire more workers? We do know that it's a tragedy, that it devastates the workers being thrown in the system. That we know. So to cause this tragedy, is it worth it? What are they getting in return? And like Representative McLean said, in his prayer, I'm all for what's fair for the worker, what's fair for the employer. So why are the employers pushing this so hard? What are their numbers?
Okay, Representative McLean.
Thank you, Mr. Chairman. I guess what I like to ask is, do you think this bill improve the experience of a worker, or do you think this is just a cost cutting on the employers for their insurance? I'm just going to get to the chase, as Chairman Bonner said. Kicking it down the road is this a cost cutting for the insurance policy? I don't know. Maybe you may not be the one I should ask this question to, but is this the reason? Is it insurance cost? Is it cost cutting? Because it definitely cannot be an experience for a worker to be out of work and not get funds for 16 months.
That's a good question, Representative McLean, and I think the answer is that it's totally cost cutting for the employer. As far as for the worker, it creates a system where there's such a delay in getting benefits, and it's arbitrary. Some companies are fair. I like, there's some attorneys, Brian McElreath, he's a good attorney. I like working with Brian. But there's some attorneys that aren't, and so we're taking away the rule of law, and instead it's just arbitrary. What does the insurance adjuster feel like that day? They don't like the fact that the worker didn't have surgery, cut off the benefits.
Okay.
So it absolutely hurts the worker.
We've got to
Thank you,
shorten
Mr.
some of these answers. Okay, Whip Park.
Thank you, Mr. Chairman. So I'm trying to understand the implications that this bill would have with existing law. In particular, OCGA 34.911, which provides the exclusive remedy provision, which would prohibit or prevent an employee from suing an employer if the employer provides for workers' compensation. By saying that, employees, that the state-based workers' compensation would not apply to these employees who are under the federal protection, would these employees now be able to sue their employer through the civil process with the workers' compensation immunity now being removed?
It is a different body of law, but I think the short answer is no. I mean, there's still workers' comp provided through the Department of Labor program, and that does create a bar where if your leg's cut off and they don't pay your benefits for 4 years, you can't sue for anything but workers' comp. You can't sue for negligence.
But if the Georgia workers' comp protection no longer applies to these employees would then be able to sue their businesses who are supportive of this legislation. Is that a correct understanding, or am I?
I don't think so. I think there still would be a workers' comp bar because there's still workers' comp under the Longshore Act. And that does state that you can't sue for negligence. All you can sue for is workers' comp.
Thank you.
Okay, that completes. Okay, Aaron, is that Foiler or Olive? Aaron, come on up.
Thank you, everybody, for taking the time to hear from me today. I am a worker that got injured.
Speaking to the microphone because it's also being recorded. Thank you.
Can you hear me better now?
Yep.
Thank you for taking the time to hear from me today. I am an injured worker that got hurt and filed underneath the federal program. I was injured in Afghanistan. I'm a father of 3. And speaking to those, since I returned home and getting treated, I've had my benefits suspended arbitrarily 3 different times. One was for a lack of a following of a adjuster missed an LS 200 that I submitted to them. That was took a month to resolve. The second time it was a 10-month ordeal, and that has been going on for 30 months now, and I still have not been compensated for that period of time. And we've gone through preliminary hearings, and they still, it's caused my family's home to go into forbearance, and it put me into a place where I have had to have surgery, and that surgery has gone sideways and caused me to have permanent nerve damage. So I'm sorry, I'm getting...
That's fine. You're good.
Obviously, with the loss of that amount of time, every time it happens, and again, it happened this year, it is very traumatic that it triggers issues. So.
Okay. Thank you for coming, testifying. All right. Don't see any questions. James Williams.
Good afternoon, Chair, members of the committee. Thank you for allowing me to testify today. I'm speaking in opposition of passing the bill at this time. As Bruce Carrera mentioned, I serve on the State Workers' Compensation Board. I was assigned by Chairman Vincent to the subcommittee to study this particular bill last year. We did meet in Jekyll Island. The various folks put in briefs and papers and information. And we talked for a few hours there trying to hammer out an idea on this. And when we finished, the chair, Tracy Leonard, said that she would like to continue this conversation, continue to have meetings and get more information. And I believe, and I don't want to speak for Chairman Vincent or Chair Potter over the Legislative Committee, but I believe that's where the neutral stance comes from. We haven't done a complete study on it. Right now, we're looking at the longshoremen, we're looking at gateway terminals. But under the Federal Act, this is any intercoastal waterway or byway. So you're talking rivers, you're talking barge traffic. So we don't know how many workers this would affect by this particular bill. We don't know if there's a Georgia State employee on a barge taking water samples. If they get injured, do they not have the right to file under Georgia Workers' Comp? Because under this law, they're on the maritime waterway. So would they file in Georgia, or would they only be allowed to file on the federal government level? We need to look at the fees. There's just a lot of more research and a lot more study that we need to come up with and accurate. And this is why the State Workers' Compensation Board exists, is to do these difficult tasks. So I would just say pushing forward with this bill would be a disservice to the workers. It would be a disservice to the Workers' Comp Advisory Board. And honestly, it would be a disservice to this committee, because this committee made the choice to allow us to dig into this and find the decision to give for you, whether it was for or against this legislation. So I would just ask to wait and let us do the work that we've already been working on and that we're continuing to work on, so we can come up with an accurate decision. You guys have the information that you need to make a proper decision. So that's all I have today.
All right, thank you, sir. All right, there's no questions. Matt Campbell?
Thank you, Mr. Chairman, members of the committee. Matt Campbell. I have the privilege of representing Gateway Terminals, which is one of the largest employers, especially on Savannah. In the state of Georgia, they employ several thousand people. Some are here today, obviously. So I'm not going to speak very long. You know, this was talked about extensively last year. It was assigned to a committee, which has been referenced. The Workers' Comp Board created a task force, and Brian McElreath will be coming up here shortly. He is of counsel of Gateway Terminals, and he was also on this task force, so he can go into more detail about the issues and clear some things up. I will say this is not an attempt to strip something from an employee. This is an attempt to correct the system, a flaw that has been addressed by many other states on the coast. That Georgia's ports, who we rely on, is a huge economic driver, not only for these good jobs that have been mentioned, but to bring many of their products into the state, out of the state, and keep this economy thriving. They have addressed this problem, and you know, I believe as a Georgia citizen that we need to look at it and address it as well. So Brian McElreath, you'll come up and answer any questions. You want him here or up front?
Either one. Okay. Yeah, I don't see any questions. All right, Brian.
Thank you, Chairman. I'll keep my comments brief and hopefully respond to any questions that you all have from the support side. But my comments...
Pull that mic just a hair closer. Thank you.
My comments, I basically wanted to sum up into addressing the disservice or the tragedy that this would potentially be to longshoremen and women. The Georgia workforce is approximately 5 million people. We're talking about roughly 5,000, even if you double it, 10,000 people. That Georgia workers' comp system, or their 82,000 roughly federal employees, all those other folks, the 5 million minus 5,000 or 5 million minus 10,000, they're all covered by one system. So to go back to the gentleman's prayer, we are just asking for equality for both employees and employers. The only employer that's saddled with the burden of carrying two coverages are maritime employers. Everybody else, if you're a federal employee, you're covered by FECA, you're covered by DBA that the gentleman and Mr. Caraway spoke about. If you work on Fort Stewart, you work at Henry, you're covered by the Non-Appropriated Funds Act. If you're your brothers and sisters in arms that are federal politicians or federal judges, you're covered by FECA. If you're a railroad employee, you're covered by FELA. you don't have an avenue to state workers' compensation. And then there are approximately, 5 million minus 5,000 minus 82,000 that are covered by just the state workers' compensation system. And although there will be anecdotal times where the system isn't adequate, that isn't best addressed by having two systems. Those anecdotal incidents are unfortunately always going to exist. So a couple of other things, and then I would love to address any questions that you all have. I think Mr. Caraway corrected the misstatement about the 16 months on Samuel Green. As Mr. Caraway noted, Samuel Green's accident, he was the plaintiff's attorney, I was the defense attorney, Gateway was the employer. That was an accepted accident, as Mr. Caraway noted. Subsequently, it came to light that Mr. Green had a car wreck that could have been an intervening accident. And his benefits were stopped at that time. They were stopped for 16 weeks. They were resumed, and he's being paid now. There was no 16-month period ever. As for the pool that the gentleman on the left asked about, there is an accident and sickness pool. It's basically an in-house short-term disability plan, and it does provide for weekly benefits, not as robust as the federal or state system, but there are weekly benefits in an in-house accident and sickness fund. I wanted to address, will the premiums go down, that Mr. Caraway brought forth. You have one policy that's federal, you have one policy that's state. We don't know what will happen with the federal. It might go up slightly. It might do that whether there are one or two policies. But if you take the requirement for one policy away, you can guarantee that those premiums are going to go down. It's going to allow you to hire more folks from the good state of Georgia. And it's going to allow the port to continue to grow and to continue to maintain its competitive advantage over its sister state, South Carolina, that has concurrent jurisdiction, and to keep from being caught by its bookend states, Florida and Virginia, that do not have concurrent jurisdiction. Georgia, the fastest growing port in the nation in 2024. The port of Norfolk, or Savannah, was the fastest growing port in the nation, not Georgia. Port of Norfolk was 6. I think Port of Jacksonville was 7. Port of Miami was 8. Those are the states that you have to worry about, are those non-concurrent states that are nipping at your heels. You've lapped Charleston many times over, but the way that South Carolina could get back within eyesight of Georgia would be to do what we're asking you to do first. And then that means fewer jobs for the good, hardworking folks of Georgia. The gentleman, Representative Park, asked about the exclusive remedy. So there's a state federal workers' compensation system. There's a federal workers' compensation system. Although it seems odd to say they're exclusive remedies when you can have concurrent remedies, they're both exclusive remedies. They're both exclusive compensation remedies against the employer. So even if you do away with the state and it becomes an exclusive jurisdiction state, it would still be an exclusive remedy in the workers' comp system. I think those were all the clarity that I had. If anybody has questions, happy to address.
Okay. Representative McLean.
Thank you, Mr. Chairman, and excuse me, sir. Thank you. Oh, no, thank you. No, I'm sorry. I want to get out too, because, the one that President Mosley said was, it takes 16 months to even get a hearing. Now, you didn't address that at all. Is there was a reason you didn't address that, or is that common? I don't know.
Sure, happy to talk. Thank you for the question. I thought the 16 months, he then subsequently looped in Mr. Green that he said was 16 months. That turned out to be 16 weeks. It depends on what happens. If the case is denied from the beginning, which the thing that we should always keep in mind is.
No, excuse me. I'm not talking about what Mr. Caraway said. I'm talking what the president said. Okay, all right.
Yeah, I believe the president was the gentleman that had the letter from Samuel Green. That was the same one that Mr. Caraway referenced. But getting to the 16 months, in any of these protracted litigation span cases that we're talking about the 5 to 10% of cases that are controverted. As Mr. Caraway noted, Gateway is an exemplary employer. 90 to 95% of these cases are accepted. The good folks of Georgia get injured, and they mostly go back to work. and Gateway pays their wage replacement benefits and provides their medical, they don't see me, they don't see Mr. Caraway, they don't see Mr. Loberbaum. So we're talking about that 5 to 10% of cases that may be denied for whatever reason. And so then it depends on when that denial occurs. If it's denied right out of the gate, the person never gets paid, they can refer that case up after 30 days and probably have a hearing within 6 to 8 months. Now, it will take some time to get a decision and order back from that judge, and that can be anywhere between 1 to 3 years. Like Mr. Caraway, I litigate in multiple states. If you litigate a case, and this is my anecdotal experience, there's no case study on this, but when I've litigated cases in Virginia and Florida, it typically takes 1.5 to 2 years. Those are non-concurrent states. When I litigate cases in South Carolina and Georgia, it typically takes 2.5 or 3 years. Those are concurrent states. Is that because they have to weigh a state statute and a federal statute and kind of educate themselves on what's going on? I don't know, but that's just my experience. But I am acknowledging, yes, it can take a while to get to those.
Okay.
Thank you, Mr. Chairman.
Carpenter Bonner. Chairman Carpenter.
Let me ask you a question. Do you think there would be a lot less heartburn over removing this capability in the state of Georgia if we were able to adopt the same pay scale as the feds do? So, for instance, if we made a decision in code to say the feds are paying you by the hour to do workers' comp work, the state should pay that same rate. Do you think there'd be a little bit less heartburn from the other side of this issue to get rid of it? Because to me, that illustrated a big issue for me was when you're making 25% in the state of Georgia and you're only getting paid by the hour with the feds, it's almost like you're taking away somebody's upside. And I'm not against people having upside, but at the same time, you're asking the citizen, you're asking companies in Georgia to pay for that upside. So do you think that would slow down this conversation?
I think that's a great question. It's also a difficult question because does the contingency fee make things more enticing for plaintiffs' attorneys? I've never been one, but I assume it would because 25% of $2 million, like Mr. Caraway said, is $500,000, right? But could workers get hurt if you went? Well, I guess if you went to an hourly rate, I would say if anything, you should go to an hourly rate in Georgia because what happens is people with small cases have a hard time finding attorneys. If it's a contingency fee on a finger case, and that finger's worth at most $4,000, 25% of that's $1,000. You're going to be hard pressed to find an attorney that will represent you on that. So that's where the federal case is superior because it allows them to charge $400 or $500 an hour, and they may only recover $4,000 that the finger's worth. But if I fight that for some reason, I could end up paying them $50,000. Does that answer your question to some degree?
Follow, Chairman. Yes, and so that brings up another point just in my head. Do you think that some of the clog in the federal system is because they're getting paid by the hour, and so they keep pushing? Attorneys for the employee are pushing stuff that because they're getting paid by the hour. Does that make sense? That
does make sense. I would brag on the guys and gals that litigate on the Southeast or on the East Coast. They generally don't litigate about their fees in this area. Is that a problem in California? It absolutely is. The clog in the federal system is, as Mr. Caraway noted, it covers defense-based contractors, it covers non-appropriated workers. And when we withdrew out of Afghanistan, there were 14,000 people that filed contemporaneous PTSD claims and flooded the system. A system that was already overburdened, and it just brought it to a screeching halt.
Perfect. Thank you so much. Appreciate it. And kudos to you guys for that compliment. Thank you for doing what you do.
Wood Park.
Thank you, Mr. Chairman. So I'm just trying to better wrap my head around the exclusive remedy component. So if this bill passes and we are an exclusive state and a federal judge rules that federal workers' comp does not apply, would that employee then be able to file a lawsuit against the employer?
Possibly, if it doesn't apply because they're not an employee, then the exclusive remedy wouldn't be a bar, because the exclusive remedy is only a bar to employees. If they ruled that the work comp doesn't apply because they didn't have an accident, they were an employee but they didn't have an accident, then the exclusive remedy would still apply because they are an employee. Does that make sense?
To a certain extent, I mean, does the state workers' comp component, does that not also serve as a shield to employers, right? In which, if that's then removed under this bill by moving to a exclusively federal workers' comp situation, and again, a federal judge rules that federal workers' comp claim is not under their respective tests, right? It won't move forward. That employee or the employer would no longer have that exclusive remedy immunity shield from lawsuits. Is that correct? So essentially, this bill could open employers up to greater liability. Is that a possibility?
I guess it's a possibility. It would depend on why they ruled against them, but there's an exclusive remedy shield under both the state workers' comp act and the federal workers' comp act.
Mm-hmm.
So if you did away with one, the exclusive remedy shield still stands. Would there be potential tort liability if someone said you're not an employee? Absolutely.
Thank you.
Representative Hawley.
Thank you, Mr. Chair. I'm going to go straight to it. Have you lost confidence in the Workers' Compensation Board to meet again to be able to come up with a compromise?
Have I?
Yes.
No, I would say the both sides met in good faith and had a lot of promising discussions, and then yeah. I mean, if you want to know the answer, I can tell you.
Yeah.
There was one individual that wasn't on my side that said you can't be a little bit pregnant. Either you're concurrent jurisdiction or you're not, and I'm not interested in anything else. And both sides, I think, were kind of flabbergasted about that, and that was the breakdown. I mean, everybody else, there seemed to be an arm's length negotiation, like we're talking here, like there were reasonable discussions and trying to craft reasonable remedies.
And I understand that, and I know you being an attorney and understanding that a lot of the anecdotal lessons that you learn practicing in jurisdictions, when a judge will grant you a reset or maybe put it towards a continuum to give parties to meet again. Sometimes they go into arbitration. You come out maybe because there's pressure upon you, it might provide maybe a faster resolution. And so the only reason why I bring that up here is because, granted, this is probably our third week. We're crossovers. It's a little way off. If with the pressure of us all being in the room, if this were even to be reset a week for you all to meet again, would it be clearing your conscience to be able to say, you know what, perhaps because of the pressure there, it won't be so one-sided, that perhaps there may be a compromise that will work better upon our conscience to be able to either deny or pass this bill?
Okay, let me help answer that, because then we saw an example last week. If y'all know anything about me, we had a bill last week that the two sides could not have been further apart. And we spent hours negotiating to come up with a compromise. I tried that this week, and you answered it. And to your point about being a little bit pregnant, that's the problem with this bill, and that's what I don't like, not about the bill, but this type of bill. There is no compromise. You either do it or you don't. It's, if you have a bill to change the flag, which was debated, years ago, there's a lot of compromise of what goes on the flag and what doesn't. If you have a bill to change the state flower from a daisy to a daffodil, there is no compromise. So I don't see how. They did meet. They came away, and of course, everybody on that committee is not going to have the same kind of answer. But this type of bill, because everybody in this room knows I've talked to most of y'all at length, and there's no compromise. We're either going to go to a concurrent system, or we're not. And so that's the problem with this, or not the problem. It's the nature of this type of bill. So I don't see any more. Well, yep. I'm sorry, Representative McLean.
Thank you, Mr. Chairman. I guess I need to be fair in everything that I do because, so what kind of compensation do you get from for work and doing these cases?
Sure. I get paid by the hour just like the federal plaintiff's attorneys. I just get paid 40% of what they do.
Okay.
But I don't have to win to get paid. They may or may not have to win to get paid depending on how the
okay,
case
so
is.
you get paid regardless if you win or not. And,
All right,
okay.
but we're
Thank you.
straying away from the bill. Yeah, okay. All right. That exhausts questions. Unless there's someone in the audience that would like to, that did not sign up. I see a hand raised. Come on up.
Thank you, Mr. Chairman. I thought I had signed up. My name's Ralph Lorberbaum, and I appreciate the opportunity to talk.
Move closer to the mic.
I spoke twice last year,
Right.
but we had a separate issue at that time, as you mentioned, with this double dipping. I'd just like to start out by saying that I saw Ron Stevens here. I'm one of his constituents from Savannah, and he does a great job for us. We may not agree on everything, but he does a good job. The thing that I want to point out is that there's over 12,000 cases pending in front of the United States Department of Labor on cases to be decided. There are 34 judges due to the president's request for people to take early retirement, opt out. The staff in the judge's office, and there's 7 judges' offices around the country that hear these kinds of cases, longshore cases, the staff has been reduced to 1 or 2 clerks to help write the opinions for these 12,000 cases. Insofar as the length of time, it typically takes, where a controversy is filed, anywhere from 1 to 4 months to get what's called an informal conference, where you have to talk with the Department of Labor at a lower level and see if they can work the matter out. Once that happens, and they issue a recommendation, it's not an order, they're not judges, they're not even lawyers, you can ask for a trial. Savannah, all cases from Savannah are being handled out of the Covington, Louisiana office. It typically takes a minimum of a year from when the case is filed in their office to get a trial. And it typically takes anywhere from 1 to 3 years from the day of trial to get a decision from the judge. Now, as I see, the biggest problem that is going to happen if you eliminate concurrent jurisdiction, forgetting the whether or not you can sue your employer, is going to be there is nothing to stop the carriers and the employers from controverting every single claim. Why? Because they know it's going to take 3 or 4 years for a judge to make a decision. Under the state workers' compensation system that we have, if a claim is decided or if it's not, you can get to a hearing within 60 days. If the claim has been accepted, the carrier cannot suspend benefits without a hearing if the authorized treating physician hasn't released the claimant. Under the longshore system, the carrier can just go get a report from a doctor. Maybe he's in California or he's in Maine. We don't like what's being done. We're going to stop the benefits. So what you're going to do is increase the number of claims and the length of time that it's going to be to get these workers their benefits.
Okay. Let's answer a question and move on, because you testified at length already. Okay. Okay, what part?
Thank you, Mr. Chairman.
Yes.
This question may not necessarily be for you, but for the Gateway representative along with the attorney, and I certainly appreciate your
Sure.
presentation. But so for the employer, if we move to a exclusive federal jurisdiction, given the timeline, what's the plan for injured workers in the meantime, given the clearly longer period of time in which they won't receive any benefits whatsoever?
Sure. Well, love to address that. So, again, 90 to 95% of cases are accepted. People are being paid. 5 to 10% they're not. And the hammer hanging over my head in that instance are the attorney's fees. If my client doesn't pay compensation to the injured employee within 30 days of their injury, the genie is out of the bottle on attorney's fees, and I owe opposing counsel's, not me, my client owes opposing counsel's fees throughout the lifespan of that claim. That genie cannot be put back in the bottle. And those fees at an hourly rate. That's a great benefit to the employee because that they are made whole, and the opposing counsel doesn't get 25% of their money. They get paid in addition to by my client. So my client's exposure becomes paying not only the employee, the injured worker, but also paying those fees in addition to, which can be $50,000, $60,000, $85,000.
I think just especially from hearing from, workers and their personal experiences, how heartless would it be to move forward with this in which we're leaving injured workers ultimately hanging? I mean, this is certainly not my area of expertise, but the exclusive remedy aspect aside, or including that, I mean, ultimately this seems that it could potentially, provide some short-term benefit with respect to lowering insurance premiums, but open them up to greater liability. But for workers in particular, this seems incredibly harmful, especially, given the testimony that we received today. I have a very difficult time understanding the benefits that this would have, certainly being in this committee in which we've been as intentional as possible to pass legislation that benefits or provides parity for both employers and employees. Where is the employee benefiting, especially if injured in those instances, let's say those 5 to 10% instances in which this goes to litigation and it's a complex case?
Well, I think I can maybe fall on a sword that helps explain. I acknowledge that all 5 million Georgia workers would be better served if all employers were required to have both state and federal coverage, right? Duplicative coverage will cover more gaps. And if you did 3 coverages, it might cover even more gaps, or 5 coverages. But I think 4.95 million workers are covered by 1 coverage. The employers of those 4.95 million employees are only required to have 1 coverage. I think fairness dictates that everybody be treated equally.
Would you say that there's a difference with respect to risk of workers versus the work of longshoremen?
Possibly. I mean, if you work as a Walmart greeter, longshoremen work very hard. Longshore women work very hard. I do not deny that. There are tons of state workers that do construction and manual labor, bridge builders that work very hard. I think those cases are always going to exist in every scheme.
Clearly, the state of Georgia has a concurrent system for a good number of years for a certain reason, specifically with respect to longshoremen. I have not yet heard a reason on behalf of employees as to why that should change, other than a direct short-term benefit of employers potentially lowering their insurance premiums to the detriment to workers.
Okay, that's a fair question. I think the benefit to employees would be the continued growth of the port and the expansion of jobs. Longshore men and longshore women work very hard. Most of them don't have a college degree, and most of them make far in excess of 6 figures. These are jobs that would not be available to people of similar education. And I think continuing to grow the port allows those jobs to grow and those hardworking constituents to have jobs that they couldn't have with their current life experience, well-paying jobs that allow them to provide for their families.
Are you asserting that the concurrent system is what is inhibiting growth of the port?
I think the port is growing very well, but I think you could really unleash the port even further absent the concurrent system. Florida doesn't have it. Virginia doesn't have it. They're having banner years that they haven't had previously.
Even if workers know going in that they may not be able to receive benefits for months if they're injured?
I think under the state system, they may not be able to. If a case would be denied under the federal system, it would likely be denied under the state system. There aren't different versions of deny. I mean, a denied case would be a denied case no matter which forum you were litigating in, you might have a quicker avenue to a remedy under the state system.
I'm not aware of a 12,000 case backlog at the state level, at least right now. But I appreciate your answers. Thank you.
Yes, sir.
Chairman Petrie,
Thank you, Mr. Chairman. Move to pass.
we've got a motion. We have a second. Any discussion? Whip Park?
Motion table.
Second.
Okay, we got to handle that first because that takes precedent. On the motion to table, all those in favor say aye.
Aye.
All those opposed? No. All right, let's do a hand count. All those in favor to table, raise your hand. 4. All those opposed? Okay, that motion fails. Back to the motion to pass. All those in favor say aye. Aye. All those opposed? No. Does anybody want a hand count? I do. Okay. All those in favor say aye. Or raise your hand. Got it. Okay. All those opposed? Okay. The motion carries. We're adjourned.